Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the help desk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinars today, brought to you by the Southeast Asia IP SME Helpdesk project and the European Chamber of Commerce in the Philippines. We will talk about increasing post-pandemic innovation with intellectual property. Before we get started with the presentation, I would just quickly go through the housekeeping rules. So we would like to have an interactive webinar today, so we would encourage the participants to send us any questions that you may have through the question mailbox, and we will discuss your questions live at the end of the presentations during the Q&A session. We also would like to remind you that today's webinar is recorded, so you will have access to the recording a couple of days after the presentation. And I would like to give you a quick overview to the Southeast Asia IP SME Helpdesk project. Myself, I'm the project manager of this European Union initiative. We offer free of charge first-line advice to European SMEs on intellectual property rights. On the slide, you can see the services. So we have a helpline. We can answer any IP question within 3 working days. We organize trainings across the year in Europe and Southeast Asia, and of course online. And we have a wide range of materials available to download on the Helpdesk website. And the most important is that all services offered by the Helpdesk are free of charge for EU SMEs. I wanted to show you just quickly on the next slide that we have an IP fact sheet on the Philippines that you can also check on our website. And this gives you a very brief practical overview about the IP landscape of the Philippines. So feel free to check it out after the presentation. And without any further ado, now I would like to give the floor to today's webinar's Master of Ceremony, Ms. Atty Divina Ilas Panganiban. And now the floor is yours, the chairperson of the Intellectual Property Rights Sector Committee of ECCP. Thank you.
Thank you, Nora. Good afternoon, Southeast Asia, and good morning, Europe. A very warm welcome to all of you. My name is Vina Ilas Panganiban, and it's an honor to be your master of ceremonies today. We have an extremely interesting set of presentations lined up for you this afternoon. So allow me to thank this early our esteemed speakers, ECCP and Southeast Asia IPSME Help Desk for putting this event together. Of course, I would like to thank you, our dearest audience, for joining and signifying your interest to listen to our webinar entitled Increasing Post-Pandemic Innovation with Intellectual Property. Okay, we have a packed agenda ahead, so let's jump right in and get started. It's with utmost pleasure to introduce welcome our keynote speaker for today. Joining us is the Honorable Rowel S. Barba, the Director General of the Intellectual Property Office of the Philippines. Before his appointment as Director General, DG Barba served as Undersecretary at the Department of Trade and Industry, where he was concurrently the Chief of Staff of the Secretary. In this capacity, DG Barba was the Secretary's alternate representative in presidential cabinet meetings and was the lead official for the organization of presidential visits within the department. In addition, DG Barba used to supervise various offices, attached agencies, and boards under the Office of the Secretary. On top of his current role as Director General of IPOPHL, DG Barba sits as a governor of the Board of Investments and is the acting chair of the Cagayan Economic Zone Authority. DG Barba obtained his bachelor's degree in political science and Bachelor of Laws degree from the University of the Philippines, which we proudly claim to be the country's premier state university. When he was in UP, he was also part of the editorial board of the Philippine Law Journal. Friends of the chamber, please welcome. He is to many the best dressed Director General of the Intellectual Property Office, DG Rowel Barba. Thank you for joining us today, DG.
Thank you very much for that very kind introduction, Attorney Vina. So, ladies and gentlemen, good afternoon. I remember it was also the European Chamber of Commerce of the Philippines, or ECCP, which hosted my very first virtual webinar during the ECQ in 2020. So, thank you to the ECCP and the Southeast Asia IP SME Helpdesk for taking this time to again put the spotlight on intellectual property. IP will certainly be playing a huge role in our journey toward recovery amid a tech-driven new normal. The tech and digital space has indeed presented invaluable benefits and boundless opportunities to many. At IPOPHL alone, our digital transformation agenda proved indispensable in rising above the challenges of the pandemic and ensuring IP protection remains accessible. Before the pandemic, IPOPHL had already been aggressive in modernizing its systems. But when COVID hit, we doubled our modernization and digitalization efforts, making us among the first government agencies to offer end-to-end online services. Aside from digitalization, we have also been adopting fourth industrial revolution technologies to improve our overall work from decision making to implementation. Last year, we launched our Business Intelligence 2.0, or data visualization platform that uses cutting-edge machine learning, or AI, and advanced analytics features. This tool enhances our existing big data analytics and infrastructure and dramatically improves our evidence-based decision-making processes using real-time data visualizations. Thanks in large part to our innovativeness in improving service quality. IPOPHL has earned its place on the map as noted in the World Trademark Review's 2021 IP Office Innovation Ranking. From 24th place in 2020, IPOPHL jumped to 9th last year, making the Philippines the only developing country to have an IP office in the top 10 of the 60 offices ranked worldwide. We even outranked Japan, US, and France. But with all the good we have seen in innovating and going digital, we are also seeing how this new space aggravates IP concerns in ways that are more challenging than ever. For IP rights holders, these challenges center on how they can best protect their IP rights. In a world where content can be copied and shared in an instant, where violators can hide within the dark web, and where content and commercial posts that have been taken down can be easily used different entity. Next. In 2020, IP rights enforcement or IE 151 counterfeiting and piracy reports from consumers and complaints from rights holders. This surpasses the previous record high in 2020 and records a 25% year-on-year increase. About 75% of these were on counterfeiting and the remaining 25% on piracy. Above all, the latest IEO data show that piracy and counterfeiting continued to rage in the online space, as 90% of the reported violations took place in e-commerce platforms, social media, and other websites. One positive indication we found is that concerned netizens are actively helping protect IP rights, as they contributed 75% to our IEO's total reports. This trend shows that there is a greater vigilance in the public and appreciation of the economic importance of respecting IP rights, especially as we are now shifting gear towards a faster post-pandemic recovery. To further strengthen IPOPHL's enforcement efforts, we issued new rules to expand our enforcement functions online and make more remedies available to rights holders. The rules include enhanced coordination with the National Telecommunications Commission to take down posts that violate IP rights and proactive monitoring of marketplaces. Unfortunately, we still have to get NTC's response to this. We have also broadened our network of private sector partners to better understand the challenges we face and develop more efficient and more harmonized enforcement measures. We have also facilitated the successful partnership excuse me, between e-commerce and rights holders last year, thanks to the help of Attorney AJ, which resulted in more takedowns and more proactive measures among platforms and organizations. On top of this, we are pushing to implement a rolling site blocking regime, which will continuously block access to IP infringing sites and prevent illegal content from getting back online. So we see this as a really disrupting access to pirated content online. For our determination to establish a site blocking regime and help our content creators feel safer and more empowered to create in the online space, we have been recognized by the Motion Picture Association of the US as a government leader for site blocking in Asia Pacific. Recognizing the need to address these challenges, excuse me, and continue incentivizing IP generating activities, IPOPHL has been implementing a holistic approach through policy and raising awareness on IP. The LEAP seminar, a weekly learning event that provides a basic overview of the different types of IP, so the number of attendees jumped 44% year-on-year to 1,696 when we shifted online in 2020. As of June this year, the internet-based learning event has gained a 6% increase in attendees compared to the January to June in 2021, indicating the continued interest of the public to learn IP. IPOPHL also holds the IP Leap Forward, which offers advanced IP seminars catering to specific industry or audience. The office also accommodates company requests for private seminars when possible, such as the recent seminar with the advertising firm DOOH, and last year with Golden ABC, which owns Pen Shop and other local brands. Aside from providing regular and special learning events, IPOPHL has also been intensifying its awareness campaign through social media and communication to the public by addressing common questions about IP. What's more, we recently launched the IPOPHL Learning Activities Workspace, or which we call ELAW, marking the first time an IP office in Southeast Asia offered an online learning system to promote IP awareness. Our efforts did not only widen IPOPHL's reach throughout the country, but also help to realize the importance of IP as a tool for recovery among our people. Our aggressive efforts to promote IP was evident in 2021, when total applications filed at IPOPHL climbed at 11.6% from 2020. This was only less than 400 applications short of our record high before the pandemic. Filings in 2021 for patents increased by 5%, trademarks by 4%, and utility models by 3%. For copyright, an impressive 128% increase in 2021 registrations was recorded. Like everyone, IPOPHL hopes to see the country back, stronger with no one left behind. For this, IPOPHL has provided a wide array of inclusive promoting programs. Whether for an MSME, an under-resourced inventor, or an independent artist, there is always an IP program to have them register their IP assets. But beyond helping them protect their IP, the ultimate goal is to help them appreciate how IP can be a game changer in building their competitive advantage. Our Wanna Make a Mark program and Wanna Patent and Wanna Invent program offer waived registration fees for women-led entrepreneurs and inventors to help empower women and increase their participation in business and innovation. Our One for the World program aims to be the ultimate incentive package to help MSMEs succeed globally through trademark protection by using the Madrid Protocol and other capacity building assistance. Our patent cooperation treaty continues to help investors to go global through assistance and waived fees. Of course, these MSME efforts would not have as much impact and reach were it not for partners who have helped promote IPOPHL programs. One of the office's long-standing partners is no less than its mother agency, the Department of Trade and Industry. Several organizations, such as the Philippine Franchise Association and Philippine Retailers Association, have also partnered with us in implementing the One for the World. We hope we could also work with foreign chambers like the ECCP to achieve our shared goal of recovery and prosperity for all. One area we can work with is in innovation. As innovation and IP are essential in building a forward-looking and more progressive nation, the Philippine Innovation Act was signed into law in 2019 to guide the country's innovation goals. This would also make the policy environment more conducive for science, technology, and innovation to foster. In parallel, the Innovative Startup Act was also enacted to strengthen, promote, and develop an innovative and entrepreneurial ecosystem and culture in the Philippines. To realize this goal, IPOPHL's own Documentation, Information, and Technology Transfer Bureau, or the ITTB, has been working with the Asian Institute of Management, Lado Banatao Incubator, to help startups in drafting patent claims. Soon, we will also be working with other startup groups together with the Department of Trade and Industry. IPOPHL is also aggressive in expanding its network of innovation and technology support offices, or ITSOs, throughout the country. The ITSO program supports the creation of IP in the academe and research sectors, while also extending technical assistance to entrepreneurs and inventors. The intention is to make these offices or centers more accessible to IP innovators. Currently, there are 77 ITSOs all over the Philippines, comprising academic, research and development, and support institutions. Of these, 30 have successfully commercialized their IP assets. One example here is the Samar State University, which helped create PEDDLR, PEDDLR, a financial literacy and management startup company. PEDDLR has raised over $4 million in seed fund and now employs a number of young people in the city of Catbalogan in Samar. IPOPHL's innovation strategy also taps into the talent and ingenuity of the youth. IPOPHL will soon be launching the Youth Incentive Package Program to encourage and inspire young change makers to create, innovate, protect, and commercialize their creations through the IP system. All this and many more we do to foster an innovation enabling environment in the Philippines. At present, the Philippines is ranked 51st overall in the Global Innovation Index and remains to be an innovation achiever, which means we have creating innovative and creative outputs more than what our resources would allow. We have jumped 50 spots in the GII in just 5 years, a trajectory that impressed even the world intellectual property organization. Moving forward with all our efforts in motion, we hope the Philippines will be in the top 40 of the GII by 2024. Another IP tool we see that will greatly contribute to our economic recovery are geographical indications for GIs. I am sure many of you will be happy about this. At present, IPOPHL is aggressive in developing Philippine GI products. We have been going around the country in the past year to reach out to agricultural industry groups to empower them with GI knowledge, giving them hope as they learn that they can increase the value of their products with GI registration. Our efforts bore fruit with our recent approval of the Bicol Pili as a collective mark. In the near future, we hope to have the Bicol Pili, the other local collective marks like Guimaras Mango, and other potential GI goods to be officially protected as GI as we recently finalized our local GI rules. The rules have been forwarded to our mother agency, the Department of Trade and Industry, for approval, which will effectively put the new GI protection rules in force. We hope to release these rules soon and enhance the competitiveness of our agri-goods and products through GI protection. Also, just last month, we signed an agreement with the Institut National de l'Origine at de la Qualité, or INAO, to develop more agri-products and elevate the capacity of IPOPHL in regulating and supervising and examining the application of agricultural and food GIs. We are confident that with our recent efforts, that will truly drive the greater use of GI and contribute to economic recovery. We also launched at the sidelines of the WIPO General Assemblies in Geneva, the MOU between WIPO, IPOPHL, and the La Salle University on the master's program on IP management and innovation, the first in the ASEAN region. With this, we hope to produce high-caliber IP professionals equipped to help IP assets contribute to economic, social, and cultural development. To make the IP law more robust, effective, modern, and forward-looking, we will continue to push for the amendments of the 1997 IP Code for increased innovation and a better digital future. This, in turn, would also strengthen the Philippines' position as an attractive investment destination. Before I close, I would like to gather the support of our partners in the ECCP as IPOPHL celebrates this year its 25th year anniversary as an office. With the theme Creating a Silver Bright Future, our year-long celebration aims to highlight the importance of IP protection in accelerating the country's recovery. This event by the ECCP is one great way to celebrate our anniversary, as we hope to steer discussions on IP and yield actionable insights to harness IP for economic growth, because IP-based goods could be our country's greatest untapped resource. Again, thank you and a good afternoon to everyone.
Thank you, DG Barba. Thank you for sharing your insights on the efforts and achievements of IPOPHL. After you guested in our 2020 webinar, we continue to witness the sophisticated and efficient manner the IPOPHL coped with the challenges brought about by the pandemic, and now post-pandemic. It's refreshing to hear success stories like Peddler Startup Business. The IPOPHL indeed deserves a place in the top 10 list of most innovative IP offices in the world. This is really an exciting time for the IPO. We look forward to hearing more success stories as we face the silver bright future. Okay, let's move on to our next speaker, who will dive deep on the intellectual property chapter chapter of the Regional Comprehensive Economic Partnership, as well as its impact in the Philippine digital economy. Director Nathaniel S. Arevalo started his career in the government service in 1991 with the Civil Service Commission. It was during his tenure in the CSC that he was able to study and finish his law degree. He took the 1997 bar exam and became a member of the Philippine Bar the following year. He left government service in 2000 and engaged in private law practice. In 2001, Director Nat rejoined the government and worked at the newly created Intellectual Property Office of the Philippines, particularly in the Office of the Director General. He became the head of the legal and policy staff of said office. In 2010, he assumed the directorship of the Bureau of Legal Affairs. Aside from his core functions as the BLA director, he is also overseeing the office legislative agenda, performing lead and support roles in respect of legal and policy issues and in international engagements. He is the lead negotiator on IP chapters in free trade agreement negotiations, including the Philippine-European Free Trade Association, FTA, and the Regional Comprehensive Economic Partnership, or RCEP, agreement, among others. Director Nat has always been instrumental in the development of IP adjudication procedures in the BLA of the IPO through the years. So please all, let's welcome Director Nat Arevalo to talk about the impacts of the Regional Comprehensive Economic Partnership Intellectual Property Chapter in the Philippines. Director Nat?
Thank you for the kind introduction, Attorney Linan. So good afternoon to all. It's an honor to participate as a speaker and panelist in this very significant and timely event. In the interest of time, please allow me to proceed with my insights on the impact of RCEP's IP chapter in the Philippines. So next slide, please. Just a little background. So there is now a trend to include an extensive IP chapters in FTAs, or now more commonly known as RTAs, regional trade agreements. So before, while IP is included in the FTAs, most likely the scope and coverage is focused more on cooperation activities. But according to a WTO study, the new generation of RTAs, those RTAs that were concluded in the last 10 years, contain comprehensive IP chapters for the following reasons. The first one is that funds to interest from the private sector and the negotiating counterpart, particularly the IP owners and rights holders on one hand, and on the other hand, the users of IP, for example, in terms of clarity as regards exemptions and exceptions and fair use, for example, in copyright and related rights. Secondly is the recognition of the IP's importance in the global value chain. The next one is technological developments. Today, there's a relative ease of infringing IP, the digital environment, and the creation of regional standards for IP protection, and lastly, as a negotiation chip for the broader interest in the FTA or RTA. So next slide. The RCEP, the Regional Comprehensive Economic Partnership Agreement, was signed by the member states. As you know, it composed of the 10 ASEAN member countries, Australia, China, Japan, South Korea, and New Zealand. India took part in the negotiations, which took 8 years to conclude. But India, however, did not join the rest of the member countries in signing the agreement on November 15, 2020. The RCEP agreement entered into force in January 1 this year. Unfortunately, as of today, we are still waiting for the Philippine Senate's concurrence on the ratification of the agreement. Then the IP chapter of the RCEP agreement is touted as one of the more extensive chapters, if not the most. The IP chapter has 83 articles, That articles point 11.1 to 11.83. No? In addition, there are provisions for specific party transition periods and for technical assistance. All of these were negotiated paragraph by paragraph, sentence by sentence, and word for word. And with so many contentious issues due to the varying levels of ambitions of the parties, and no wonder it took us to conclude the negotiations, including the legal scrubbing, in 8 grueling years. So that's how tedious the negotiations for the RCEP. Next slide. So the IP chapter has been described as one providing a balanced and inclusive approach to the protection and enforcement of IP rights in the region. No? The RCEP members acknowledge the differences in the levels of IP development in the region, and they also recognizes that while harmonization is a desired objective, it is equally important that members should be able to maintain policy space, including but not limited to the use of flexibilities under the TRIPS agreement to address, for example, domestic conditions, concerns, and emergencies, like public health concerns. The welfare of the indigenous communities is also covered in the RCEP, no? As it recognizes that each member country may establish appropriate measures to protect genetic resources, traditional knowledge, and folklore. No? Furthermore, as a show of solidarity and respect of social and human development, the RCEP members who are not yet members of the Marrakech Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled are obliged to accede to the treaty. And finally, acknowledging the differences in the level of IP development between and among the RCEP members and the need of some of the members for time to adjust their current legal regimes, the agreement includes provisions on cooperation, dialogue, transition periods, and technical assistance. So, next slide. What are included in the IP chapter of the RCEP? No? As I've said earlier, it is very extensive, no? Very comprehensive chapter in the RCEP agreement. Practically all areas are covered. No? So we have the objectives, and the objective is to reduce distortion and impediments to trade and investment by promoting deeper economic integration and cooperation to the effective and adequate creation, utilization, protection, and enforcement of IP rights. It also recognizes the need to promote innovation and diffusion of information, knowledge, content, culture, and the arts. And more importantly, the RCEP also recognizes the significance of IP protection enforcement and its role in innovation and technology transfers. So in principles, I think the RCEP will stipulate parties may adopt measures that are necessary to protect public health and nutrition as well as public interest and prevent the abuse of IP, no? Among other things. And one important feature of RCEP is with respect to obligations. It says that under the RCEP, parties are free to determine the appropriate method of implementing FTA obligations and provide more extensive IP protection under the national law. So while some of the articles of provisions are prescriptive, still policy space are given to member countries as regards the implementation on the ground level and domestic level. Tips and public health. So RCEP affirms the rights of the members to full use of TRIPS flexibilities under the TRIPS agreement, and it's focused on compulsory licensing. And what else? So multilateral agreements, there's an obligation under RCEP for the member countries to accede to the important treaties, international agreements on IP. You know? So I'm not going to enumerate them, but I may touch on them later in my discussions. There's also provision cooperation. The cooperation includes expanded areas na education awareness, border measures, eliminate international trade, IP infringing goods, patent, search and examination work, quality assurance, patent-based periods, procedures and processes, and GRTK-related patent examination. There's also cooperation activities with respect to protection of new plant varieties, and information sharing on preventing online copyright infringement and geographical indication protection. So streamlining and harmonization procedures, the RCEP parties endeavor to review and make improvements on IP administration procedures and requirements and transparency, and requires parties to publish information on IP applications and registration as well as legal status. Not only application registration, but also the procedures and processes. So patents, specific provisions of patentable subject matters and processes, merely affirming what's the TRIPS agreement provided, but with respect to patent, it affirms the right of parties to as an exception to patent rights, experimental use of patent. Then as regards patent examination registration procedures, it has provisions on the grace period for patents, an 18-month publication period, information made public available as a prior art, also expedited examination. This may be these provisions are or obligations are either prescriptive or on endeavor basis, best effort. Also, the patent provisions include the use of system consistent with international patent classification and a sui generis plant variety protection system. So industrial designs includes provisions in industrial designs and trademarks. The commitment under the RCEP with respect to trademarks impacts on us in the basis that we need to amend the IP code, because the RCEP says that we should dispense with the requirement that trademarks should be visually perceptible in order to be eligible for protection. So we have to remove, we have to amend our code so as to allow the registration of non-visual or non-traditional marks like sound marks. There are also provisions of protection of well-known marks and the how to deal with bad faith trademarks, and also the specific provisions on GI protection. Copyright, additional provisions on protection and right to remuneration for broadcasting, provisions on collective management organizations, and limitation exceptions to copyrights. There's also provision under competition and reiteration of the TRIPS Article 39 of the TRIPS as regards the protection to undisclosed information. The RCEP also includes, and it's also, we might say that this victory of sorts for the Philippines and other proponents of this, the inclusion of provision on genetic resources, traditional knowledge, and folklore. It's very important for us because it manifests to signify that the issue is thriving and continues to be discussed, and in the it may be far-fetched, but there is still a chance to at the WIPO level to have an agreement regarding an international legal system of regulations on the protection of GRTK in relation to IP. And then there's the enforcement provisions, and this includes judicial remedies and also border measures. And lastly, there are specific transition periods for the parties to For those parties who may need to amend their laws or change their legal system in order to comply with the obligations under the RCEP. Also, there's another one provision on technical assistance. Some of the RCEP member countries may need assistance from other members as with respect to the implementation of the obligations under the RCEP IP chapter, particularly with respect to technical issues. So next slide. And it's about the impact or benefit to Philippines RCEP. So IP chapter and FTAs or RTAs are about norms and tools. So hence, in terms of managing expectations, we should consider this as a long-term investment. Putting together the right mix and ingredients to stimulate creativity and innovation, and thus spurring activity and social development as well through new products, processes, services, literature, creative works, and activities, and transfer or dissemination of knowledge. In this regard, under the IP chapter of the agreement, I view this. I believe that the Philippines will be benefited under the following. It ensures that Philippine interests are protected in other countries with the requisite accession of parties to treaties agreements to which the Philippines is already a party. So I should say that the commitments and obligations include harmonizing the protections for the standard suite of IP rights and protection beyond the level of the TRIPS agreement, including provisions relating to technological protection measures, enforcement, and digital environment. These are obligations also under the WPPT, in the WCT, which parties to RCEP are required or obligated to accede. I should say that Filipino authors, artists, composers, and performers can now expect that their works can be protected and enforced under the same standards in the entire RCEP region. And moreover, the provisions of collective management organizations could potentially facilitate the collection and transfer of royalties due to them. Also, Filipinos seeking protection of their IPs, including inventions, utility models, industrial designs, and trademarks within the RCEP region, stand to be benefited as the IP chapter has provisions to streamline and align procedures such as those relating to electronic filing of applications and making relevant information available online. This, along with the obligation of some RCEP members to join international filing systems by acceding to the PCT, as mentioned earlier by DG Rowel, and the Madrid Protocol, are advantageous to local businesses and industries, including the micro, small, and medium enterprises, as this give them access to protection for IPs in all of the RCEP members at a lower cost and thus becoming more competitive. RCEP also fosters innovation in the country, especially as Philippines respond to digital transformation. We also see the development of local primary industry to compulsory licensing by virtue of the affirmation of the right of the parties to fully utilize the flexibilities under the TIPS when it concerns public health. So it is very timely in this due to pandemic that we have gone through and still persist. So also RCEP provides opportunity for local industries and talented, gifted Filipinos in the creative sector. The branding strategies of local businesses, for example, businesses and entrepreneurs are bolstered as non-traditional trademarks like sound marks will be eligible for protection in the entire RCEP region. And RCEP also promotes culture and arts, and protection of our natural resources. So the welfare of the country's indigenous communities is covered in the RCEP, as the RCEP agreement recognizes that each member country may establish appropriate measures to protect GRTK and folklore. And I think I've already mentioned this. It's a show of solidarity in the aspect of social human development. RCEP members are required to accede to the Marrakesh Treaty. This would give the visually impaired persons within the region the opportunity to access books and other literature to this treaty without much cost. This will benefit them. So in essence, it will promote arts and culture. Yeah. So I think this is my last slide now, and I will be glad to answer your questions later. So thank you.
Thank you, Director Nat, for sharing with us the details of the IP chapters in the FTAs or RTAs, including the RCEP. As you say, it's a long-term investment. So congratulations and thank you for starting the seeds for the Philippines. We have a lot of questions coming in already, but please keep them coming. But bear with us because we have a last and final speaker. So allow me to introduce our next and final speaker, the ever-dependable attorney Edmund Jason Baranda. Attorney EJ is an external expert at the Southeast Asia IP SME Helpdesk and the managing partner of Baranda and Associates, a member of the global IP firm Rouse. He is a recognized expert in intellectual property and is involved in patent, copyright, and trademark prosecution, as well as commercialization and licensing of these IP rights. He also litigates intellectual property actions and conducts enforcement actions. He has a degree in molecular biology and biotechnology from the University of the Philippines, Diliman, and obtained his law degree from the same university. He was admitted to the Philippine Bar in 2001. In 2007, he obtained his Master's of Law degree from the University of Michigan Law School with intellectual property as his area of concentration. He is also admitted to the New York Bar. Attorney EJ has international experience as a legal practitioner, having served as a foreign legal advisor in an established regional law firm based in Singapore. He currently teaches IP law at the De La Salle University College of Law and previously taught IP law courses at the Ateneo Law School and University of the Philippines College of Law. EJ has been with the Southeast Asia IP SME Helpdesk since October 2013. In fact, I think I'm already running out of adjectives to describe my classmate and friend, Attorney EJ. Glad to have you with us again, EJ.
Thank you, Vina. You are truly a friend. So good afternoon, everyone, and good morning those who are based in Europe. So thank you once again to ECCP and the IPR SME Helpdesk for giving me the opportunity to be part of this webinar. DG Barba mentioned that it was also an ECCP event where he was invited to speak virtually. Actually, that was also my first opportunity, I think, to also speak as a speaker in a virtual webinar. And that was at the height of the pandemic. So here we are 3 years, I think, 2 years after, and so much has changed, and that's why I was asked as well to talk about business perspective on IP in the digital economy. So let me just share my screen. Okay. This is where the digital economy is right now. 3 years, 2 years being, or although more than a year of being locked down, we've seen a lot of the public using the internet for entertainment, for shopping, etc. So we saw an explosion of the use of the internet for such activities. Whereas before, of course, we had physical stores, we had rental DVD rental stores, or we had banks to facilitate financial activities. But now everything could be done online, and it was accelerated as well through because of the pandemic, because everyone was at home, was forced to be at home. So we have all these companies in the online space making or exploiting the fact that we were cooped up in our houses. So and it's two-way. It's not just apps that are based outside the country, but also local apps that have also expanded, not just in the Philippines, but also abroad. I'm talking about, for example, Viva Max, which is a local Netflix. Anyone can now have access to Philippine movies, whether they're based in the Philippines or outside the Philippines. We also have during the pandemic, we also saw online platforms that are based abroad, but now traditionally they would not allow buyers from the Philippines to purchase or using Philippine credit cards. But again, because of the explosion of the digital economy and the popularity of online platforms, they realized that, hey, Philippines could be a major market for them. So now they're able to, well, number one, they accept Philippine credit cards, and they're able to deliver to the Philippines. So and an example of that is Amazon. And I'm not sure if you can see that there's one on the lower left. It's called Ox Street. I recently bumped into it. I'm a sneakerhead, and the problem with buying sneakers online is that there are certain websites that, number one, again, do not accept Philippine credit cards, or the delivery fee, well, they won't deliver to a Philippine address, or the delivery fee is just too prohibitive. But this one, Ox Street, is based in Singapore, so the shipping fee is quite reasonable. I think they were charging about 30 Singapore dollars for the sneakers to be shipped to the Philippines. So again, I'm citing that as an example that it's now it's easier, more than ever. It's easier to buy products online, to transact online, because now we are now in this digital age, and therefore also a growing digital economy. I'd also like to mention GCash, because I think it also revolutionized the way people pay for services or for products. I think it's known that in the Philippines, Filipinos are not too keen in opening bank accounts, or at least maintaining bank accounts, or having cash, significant amount of money in their bank accounts. But so GCash and I guess Club was cognizant of that, and now they have GCash where you don't even have to have a bank account. Although of course it can facilitate matters, but you don't even have to have a bank account to have a GCash account. So now you can exchange money online virtually through GCash. And recently they even expanded to G-Credit. So again, a person with no bank account, even without any credentials for them to be given a credit card, they can now have a credit lending facility through GCash. So that's where we are at now. And where does IP come in? For those of you who already have a background in IP, I think you understand that IP is very important in any business. You need to, number one, recognize your IP, and number two, you need to protect your IP, and number three, you need to commercialize your IP. So more than ever in the digital economy, it's very important for you to recognize your IP and protect your IP, because and digital economy and innovation, innovation actually drives the creation of IP. They're very much related. I found this nice definition of digital economy. It says it's defined as a worldwide network of economic activities, commercial transactions, and professional interactions that are enabled by information and communications technologies. In other words, simply put, it's economy based on digital technologies. And I like this definition because it's not just about economic activities or commercial transactions, but also professional interactions, which I think is something that needs to be emphasized. That in a digital economy, it's not just about paying for services, transacting online, and exchanging money online, but it's also provision or providing services, which now can be facilitated online because because again everyone's online. Like I said, digital economy and innovation are very much interrelated. It's the digital technology that drive the innovation, and of course this will fuel job opportunities and economic growth. And I've already mentioned GCash, and this is exactly what a digital technology did, which is to revolutionize the delivery of financial services. So GCash is a good example of that when with respect to facilitating payment and also for lending. Another important development because of the rise of digital technology is that, as I've said earlier, you allow businesses that started as a local business to go global. Again, this is in keeping with the trend towards market liberalization and reduced trade barriers. And Director Nat mentioned again that's a regional free trade agreement. So with that in place, which much reduced trade barriers, this is even more important now. Okay. Before I move on, maybe let's take a poll first. I just want to have a pulse of how much you know about IP. So the first question is, business ideas are not covered by IP rights and thus cannot be protected at all. So if you could, I think by this time there's a pop-up in your screen. So just answer true or false. The second poll question is, once my IP is registered, I will not need to carry on any other action and my IP will be protected automatically against infringement. So do you consider that an efficient IP protection strategy? So again, true or false. All right.
Thank you, Edmund. I just want to encourage the participants to quickly vote for question 1 and question 2, and then we will share the result and Edmund can continue with the presentation. So
Okay.
we give you a few minutes. You can make up your mind. There is no punishment for wrong answer. I can promise you that.
And we will discuss the results and maybe I can make some comments once we have the results.
Exactly.
Yeah.
Is to make the presentation more interactive, to hear also from the audience. So I think you had enough time. We can share now the results. So just to see the allocation of percentages.
Oh, okay. Wow. It's very interesting results. For the first question, it's exactly half, 50-50. 20 said true, 20 said false. And then for the second question, more people said false, 70% as opposed to 30% true. Okay, we will discuss the answers later. But it's great that you formulated an answer to these questions because it's something that we can discuss later. All right, so moving on. Okay, so again, I'm only given 15 minutes, but for the next 10 minutes or so, I'm going to talk about how IP is created and how IP should be protected and commercialized. But I found this visual very informative. It talks about the creative process, how you create products, how you provide services. It usually always starts with an idea, so a generation of an idea. So and I think all businesses go through this. When you want to put up your own business, it always starts with an idea, a great idea. Hey, I want to put up my own coffee shop. I want to develop my own software, or I want to open a new restaurant. So that's the first idea generation. And then what do you do with this idea is you develop that and find out, is your idea worth pursuing? So you do some research. If your idea is to come up with a new product, and you develop that product, you develop know-how. And then since what you intend to do is to commercialize that later on, of course, you need to talk about branding, talk about logo. What sort of branding do you want for your brand? Who's your target market? Because the way you market your product will obviously depend on your target product, on your target market. And so your logo and branding should also be should also take into consideration who do you intend to sell your products to or provide your services to. So very important step as well in the creative process. So now you have a logo, you have a brand, and you've developed a product which you think will be, or a service that you think will be patronized by the public. Then you go marketing. You think about ways to inform the public about your product and your service. And you think about all sorts of marketing activities to promote your brand. And I'm emphasizing that since we are in a digital economy, do not forget digital marketing. In fact, I think studies have shown people are now more tuned into their phones than TV. They get information on their phones rather than TV, or they read newspapers online rather than watching TV. So it's very important that you incorporate digital advertising, digital marketing in your strategy. So that will, of course, the end result is commercialization. And at that commercialization stage, you need to protect your brand. You need to protect your product, and you need to manage. Of course, you deploy that to the public, but you need to manage that product or as I explained later, that IP that you generated. Now, what I want all of you to remember from this slide is that for each step in this creative process, IP is either created, so you create the IP, or you use IP. For example, when you market your brand, you may, let's say, license a song to accompany your ad. So that's use of IP. So it's not in the creative process. It's not limited to creating IP, but also using other people's IP. And you need to be conscious that when you use other people's products or services or other people's creations, there are some legal implications there, and one of which is, of course, you need to license. So again, what I want you to remember is that in this entire creative process, IP is involved. Okay. So let's dive deeper into that. What's the relationship between the ideas and then intellectual property that's generated from these ideas, and then the market? So it starts with innovation, and I guess the message that we got from DG Barba's talk is that we are pushing for innovation. This government is pushing for innovation, because we know that innovation will lead to economic growth and social well-being. And innovation, it's not just a technical. It's not just innovations are not limited to the technical field. It could be organizational, financial, design, obviously creative and commercial activities as well. Now, it's the intellectual property that will capture and then, more importantly, protect the innovation and the creativity. And the commercialization part is this is about taking your ideas through IP protection and into the marketplace. Every company, every innovation of every company can lead to that commercialization, and then, of course, benefits to the public and to a particular sector of an economy. And we always advocate as an IP lawyer to always be conscious of your intellectual property when you commercialize. Because if you skip the IP, it may reduce the value of your company and also your revenues. I mean, some of the biggest companies nowadays, their assets are really in IP assets, intangibles. Because again, if you don't own any assets, then you're just a commodity trader, and it doesn't really increase the value of your company. So I've already mentioned intangibles, because IP is a form of intangible. And again, in this digital economy, it's intangibles and IP that will drive today's business. You can see from the graph on the left, IP is literally just a small part of intangibles. Intangibles, we can classify intangibles into, or at least you could divide them into three main types. So at the very core is the intellectual property, and those are your patents, trademarks, designs, copyrights, and trade secrets. But beyond IP, and this is what we want businesses to recognize, Okay, maybe you may not be generating IP, but you still have intellectual assets. And what are those? Because maybe you're just a trader or a distributor, you really don't create your own brands, or you don't manufacture your own products, but you do have some intellectual assets, and these are assets that you can legally own, which you can also use, you can trade or even license. So that would include contracts, your permits, your data, even your data. Or relationships with other companies that could be valuable, and even awards that you've won. And beyond that is what we call intellectual capital. So these are assets that you don't own, but at the same time, you still benefit from using that. So these are the skills of your employees, your skills, your experience, and the know-how of your team. Okay. So now that you know how the interrelationship between innovation and IP, and that you let's say you're a business that creates IP now, why do you need to protect your IP? Well, first of all, it's a tradable asset. You can license it, you can assign it, you can sell it later on, and it helps companies do deals because you are in a position to offer something that other companies would like to have or would like to license. If your IP is protected, that also means that you stop others from copying your IP, and this gives you a market position or a timing advantage. And of course, if you protect IP and you know how to use IP properly, that means that you get the necessary licenses, for example, then the use of your own company, of this IP, is protected. No one can interfere in your business. No one can stop you from running your business because number one, you protected your IP, and number two, you properly license the IP that you're using in running your business. Corollary to that is, of course, if you IP-rich businesses grow faster because it gives you an advantage over your competitors. And if you don't have an IP, that's a legal risk because there is higher financial cost if you don't have IP because you'll have to anticipate, for example, or you always have to license, for example, if you don't create your own IP, or that there could be legal costs or because of delays or disputes, then there could be legal costs because someone is saying that, some is alleging or complaining that you are using their IP without their permission. And in the product or the service, this is more applicable to products. IP is embedded in those products, and of course, if IP is embedded in those products, which gives you a competitive advantage, then it can have higher value than other commodity products. And studies have shown that SMEs that own IPRs, they have a 68% higher revenue per employee compared to SMEs that do not own IPRs. So what is IP? Again, I'm only given 10 minutes, so I really cannot talk about all of these, but I just the objective is really for those of you who are not yet aware of IP and the kinds of IPs, for you to at least to be aware of what they are. So these are the kinds of IP that you can that you create and then you protect. So again, I talked about the branding. So maybe something that's most relatable to everyone would be trademark. So that's kind of IP. So you could register your brand as a trademark, even your slogans. So or the name of your company. So some examples are there, like it's the Starbucks logo. And how do you protect that? It's not automatic. This is true not just in the Philippines, but also in most parts of the world. You need to register that. Your digital IP assets as well, they may coincide with your trademark, because when I talk about digital IP assets, these are your domain name, for example. So your www.xyz. Or your social media handles. It's something that it's not exactly a trade name by definition, but it's something that's associated with your company. So it's also important to protect that. Although you again, depending on whether it's registrable as a trademark or not, if they're not registrable as a trademark, then at least you should manage those these social media handles or your domain names. If you are involved in creating products that will embed that will use or that will bear certain designs, new designs, then you register that as an industrial design. So product shape and configuration of course I'm talking about product shape and configuration of the products that you produce. So examples of that in furniture, in packaging, in fashion design. And then in patents, so these are inventions, so any technical solution to a problem. Like I said earlier, digital economy is driven by digital technologies. So these technological enhancements or developments should be protected as patents. And last is copyright. So copyright is applies to any visual art, written work, software, graphics or music that your company produces. And so obvious examples of that would be artworks and graphics and drawings. You need not register copyright, and maybe most of you already know you don't like unlike patents and trademarks. Once you create your works, it's already protected from that moment. So from the moment of creation, it's already protected. There is an option, of course, to register that. It's more of for enforcement purposes, because it would be nice to have a copyright registration issued by a government office. So when you go to the court, it's nice for you to have that and present to the judge. But again, it's not necessary for you to enforce your rights. So all you need to do is really to manage your copyright, and I'll talk about how to manage later on. Other forms of IP it's not covered here are trade secrets. So these could be your know-how, which is not by definition not patentable because of some character because of, let's say, it's not really it's not among the patentable inventions here in the Philippines. But you can still protect it as an IP. It's considered as an IP. All you need to do is to manage that. And as already mentioned by DG Barba, geographical indications. I think there's one interesting question in the chat box about GIs, about UBE, and I think DG Barba also answered that as well. But I would like to think that, well, GIs, as you know, you can register a GI if you can trace the characteristics of that product. You can trace it directly to where it's coming from. So let's say champagne, it's a GI because only wine that comes from grapes that are grown in the Champagne region in France can be considered champagne. So ube, I think, if we can show that the characteristics of ube is traceable to where it's planted, which is maybe some region in the Philippines, or maybe it's uniform all throughout the Philippines, then you could probably register ube as a geographical indication. All right, so I'm down to my last few slides. So these are the, again, it's a huge topic, IP protection, but these are some general steps that you need to take and maybe remember when in protecting your IP. So there's this 3-step process. First is when you create your IP, well, first of all, know that you're creating your IP. You should register that, or if it's an IP that's registrable, like trademarks, patents, or you capture it, like unregistered IP, like copyrights. Capture it. When I say capture it, is make sure that you take steps so that and dispute on the ownership of that work will be easily resolved, because you've taken steps to identify to the world that you own the copyright to that piece of work. So an example of that is always adding a copyright sign, etc., or making sure that there's no dispute on the ownership of the copyright that is created, let's say, by your employees. Okay. And again, in the digital economy, since everything now is online, when you put out something online, it could be, in theory, be made available anywhere in the world. So consider registering your IP, not just in the country where you're based, but also in other jurisdictions where you intend to market your product or your service. Now, second step is the management of IP. So how do you manage your IP? Have a system in your company where you have a database of unregistered rights, so your copyrights, your trade secrets, any assignments of third party created by IP, or you have a database of your registered IP, so trademarks and patents, and make sure that you renew them if they can be renewed, like trademarks. Trademarks has a 10-year term. Patents is 20 years, but it lapses after 20 years. Designs is only 5 years, so but you can renew that twice. So again, you have to have a system by which you manage your IP. The third would be the third step in IP protection is, once your products and services are created and sold with these the IP that you created should be embedded in these products and services. And in large companies, usually it's an IT. I have an IP team that does this because you have the budget to do all of these things. But for SMEs, the challenge is really to find a way to do it internally. But again, you can ask help. The IPR SME help desk can help you with that. Okay. All right. So my last slide, some key takeaways and tips, and so I've talked about the creative process. I've said IP is created or used in almost every step in the creative process. When it comes to IP ownership, I think this one tip that we always remind our clients is if you employ people to create your IP, make sure that the IP ownership is clear, because the default rule is that if the creation of the work is part of the regular duties of the employee, then automatic it's owned by the employer. But if the creator is someone, it's not your employee, a freelancer, for example, so you just commission that person to create the work for you, let's say a website design or take a photo of your products. You must remember that the IP to that, specifically the copyright to that, is retained by the one who created it, so the photographer that you commissioned. So be very conscious of that. My second key takeaway and tip is that you should know how to recognize the IP that you create, and also the IP that you use in the creative process, and also the limitations on your use of the IP. So like I said, not all photos in the net are free. There are some photos there that allow you to use them, but there are certain limits. For example, you can use them maybe for non-commercial purposes, but if you use these photographs to market your product, that's a different matter. So be conscious of that when you use other people's IP. Obtain for permission if that work is not part of the public domain, and then make sure that your use of the work is covered by a license. So it's pretty clear what you can do with the IP that you're licensing. My third key takeaway would be when you protect your IP, always protect the IP that you create, because you can license it. There are, like I said, there are companies that their assets are purely IP and they're doing really, really well. And how do you protect your IP? You register your designs and your marks, not just with the IPOPHL, not just locally, but also in other countries where you intend to market your product. For copyrighted works, include always a copyright notice in your works. It's just you telling the world that I own the copyright to this work. It's very simple. Just Circle C, and then the name of your company, and then the year that the work was created. Now, if it's something that's not protectable by IP or not IPable, execute non-disclosure agreements with the people that will be using or handling your IP. So, for example, you're developing a product, and then you hire a manufacturer to manufacture your product for you. But it's something that you cannot patent, something that you cannot. For example, this is, let's say, a food. So the recipe for the food, it's they may not be protectable by patent or even a utility model. So execute a non-disclosure agreement for any third party that will use your IP. All right, so let's go back to the poll. The first one is 50-50. So again, the question is, business ideas are not covered by IP rights and thus cannot be protected. My answer there is, okay, can you all again answer the question, and let's see if there's any change in your answer.
Yeah, I think it's a good, thank you, Edmund. Then yes, it's a good exercise to check again if after the presentation.
Let's see if you change your answer.
Exactly. So we give it a couple of seconds and then we will share the result and go to the Q&A. Okay, as you were already familiar with the question, I think we don't need to put more time here. So let's see the result.
Okay, only a few people changed their mind. 45% true, 55% false. The answer is false. It's true that business ideas are not, ideas per se are not protectable by IP. But then there is a way for you to protect that. And this is through non-disclosure agreements. And a great example, which is often which often leads to heartbreaks, is when you pitch an idea, let's say a movie for a script. So you're a company that's involved in the creatives, and then you pitch an idea to a company. It's just an idea. So when you pitch that to that company, yes, that your idea is not registrable as a copyright because ideas are not copyrightable. So at that point, the only way for you to protect ownership over that idea is for you to require the person that you're disclosing your idea to number one, to recognize that that's an idea that came from you, and then that they should keep it confidential and should not share it and should not exploit it. So the answer there is false. Number two, sorry, the poll. Sorry, can you flash it again, Nora? No, it's gone now. But anyway, the answer,
the result.
The result, yes.
Yes, I think it was
for the second
70.
question.
Yeah, 1 second.
Okay,
Yeah,
now it's 84%. So yeah, so more people. So the answer there is false. So more people. There are people that changed their answer. It's now 84 versus 16. So yes, the answer is false. It's not enough that you register your IP. It doesn't end there because when you register your IP, yes, you're now recognized as the owner of that IP based on government records. But that's not an efficient IP protection strategy. You need to, number one, like I said, manage your IP. When you put your products out there, also announce to the world that you own certain IPs in that product. So for example, if it's a copyright, add the C with a circle, or if it's covered by a patent, let's say, you also indicate that that product is also covered by a certain patent or utility model or national design. Again, this is one way of you to communicate to the public that you own IP. So yeah, and many more things that you could do to have an efficient IP protection strategy. Okay, I think I'll end there. So we'd be happy to answer questions, and I think there are a few already in the chat box. I'd be happy to answer some of those.
Yes, thank you very much, Edmund. And I just wanted to inform you all that our moderator, Atty had to leave for an urgent meeting. So I will take over the Q&A session. And as a first question, I would like to tackle the question that we have it still open in the question box. So let me read it. What support and initiatives are needed to fully utilize the regional comprehensive economic partnerships intellectual property chapter once the agreement is ratified? So I would leave it open to all of you to answer comments. So please decide who takes who comes first.
I think that's one for Director Nat and DG Barba. So
thank you. I think it is imperative that we get the support of Congress. Under the RCEP, we need to amend the IP code to include protection to sound marks and other non-traditional marks. And also, while we are not obligated under the RCEP to amend the IP code for other areas, I believe it is desirable to include in the amendment of the IP code to enact separate laws on such issues as geographical indications, updating of the standards in IPR protection, including patents, utility models, industrial designs, and trademarks, and also in IPR enforcement in the digital environment. And we also need to obtain the support and collaboration of the relevant government agencies and the relevant sectors, the stakeholders themselves. For example, for geographical indications, a more robust engagement with the Department of Agriculture and the Department of Trade Industry, the LGUs, the local government units, and the stakeholders is needed to push a sui generis system for the protection of GIs. And may I also cite that with respect to enforcement, including border measures. We must maintain the high level in strategic interagency cooperation through the National Committee on IP Rights. We're also thankful for the support given by the Supreme Court with respect to judicial remedies. And on GRTKF, we need a closer engagement with the relevant government agencies like the National Commission on Indigenous People, the main implementer of the IPOPHL law, no? For the creation and enhancement of a database, well, for the effective protection against misuse or misappropriation of genetic resources, traditional knowledge, and folklore, and some measure to also to ensure quality patent examination and IP registration information to the issues of determining prior art and novelty. And furthermore, we need to nurture that important role of our local collective management organizations that will, because they will facilitate aspirations under the RCEP for fostering relations with the other CMOs in the region. I will definitely promote the interests of Filipino artists, musicians, and performers, among others. So those support we need to for the immediate implementation of the RCEP obligations.
Thank you very much, Atty, for your answers. Now I would like to move to the next question. Maybe this one is for you, Edmund. Can you give an update on the status of the Memorandum of Understanding signed by brand owners and online platforms in March 2021?
Yes, DG Barba mentioned this earlier in his talk. So for those of you who are not aware, there was an MOU, or Memorandum of Understanding, was executed among brand owners on one hand and then online platforms. It's really a code of conduct because there are certain gaps in our enforcement system. So and the parties have agreed on how they will conduct e-commerce online. So it has been in effect for 1 year. We think it's been working. There's an open dialogue between the online platforms and the brand owners, because of course, on one hand, the brand owners would like to see fewer ads for counterfeit and fake products online, but at the same time, the online platforms, of course, would like they don't want it to be too restrictive. They want the more participation, more sellers to be on their platforms. So the code of conduct was there for the parties to agree on how to deal with counterfeits, how to what should be the consequences if a seller keeps on posting ads for counterfeit or fake products. So it's been in effect for 1 year. IPOPHL I believe had a review. Two reviews actually already, because every 6 months there was a review. So we had 2 reviews already of the MOU. Again, it's a dialogue among the platforms on how to improve the MOU, how to improve it, what provisions should be revised or should be improved further. So we had another the second review was back in I think in April, and now it's on its second year. The platforms that signed the earlier MOU have re-signed, and we even had, I think, two more brand owners that signed in June and July. So it's an ongoing discussion. The MOU is a live document, so we would really encourage those of you who are brand owners and would like to participate in the MOU. Please you can get in touch with the IPOPHL. You could also get in touch with me, because we can facilitate your signing of the MOU.
Yes, can I just add that SCJ, we continue to promote this MOU with other brand owners. In fact, those we met in the last GA, they asked for copies of the MOU, and they will get back to us in the soonest possible time. So hopefully we'll be able to convince them to sign the MOU. And I apologize for my voice, because I'm still fighting jet lag actually. I was 17 days out of the country, so
Oh, wow.
it's difficult. No? But I cannot say no to ECCP.
No worries, DG Barba. Thank you for your answer. And maybe I can have a final question because I see that we are running out of time. There is one, let's say, more open question that could be interesting to discuss. How will intellectual property aid in the post-pandemic recovery of SMEs? I don't know if any of you have any special comments to share.
Yes, we continue to provide support to our MSMEs. In fact, our Wanna Make a Mark, we added an additional 1,000 free registrations for women-led enterprises. And that's on top of the 4,000 free registrations we have given in the past years. And we also launched Women Wanna Design and Wanna Invent to also assist our women-led entrepreneurs. And this month, actually, we will be launching the Youth Inventor Package Program to assist our youth. No? We all know that it's them who don't have the money to pay for registration fees. So we will make sure that we will be able to assist them this time.
Nora, if I could just add from a
Sure.
practitioner's point of view, yeah, it's a common misconception that protecting IPs is expensive. So, and MSMEs, we understand, have limited budget, but it's actually not expensive. And as DG Barba said, the IPOPHL has programs that help those who may not have the budget to register their IP. So there are ways for you to get assistance or get even the fees can be waived if you qualify. And at the very least, everyone should know that if your assets are below a certain level, so you're considered a small entity and you're automatically entitled to 50% off an official fee. So again, there are many ways to protect your IP, and costs should not prevent you from registering IP.
And can I also add? This is in the area of adjudication. You know, litigation is very costly, and it's scary for SMEs to engage in tedious and costly litigation. So with the approval of the DG, so we are having our ADL program in mediation outside litigation, and this is a chance for the MSMEs to avoid the litigation cost by having an opportunity to settle the disputes with other parties to mediation with reasonable fees. And we're also at this point we're still reviewing our fees if we can still lower our fee for mediation with respect to micro and very small entities. And also on matter of procedure, we also have for inter partes cases, though these are position to trademark applications and cancellation. We have the full digitalized process now. So filing is via email, and also the following processes, including the sending of the copies of the decision. So it will be very, very helpful to MSMEs to maintain the litigation should they are engaged in litigation in terms of cost. So what they have to do is only to file via internet, email system, so they won't need to go to the office or even to send their documents or pleadings by which will entail them costs in doing so. So these are the things that we very parochial, because I'm talking about my bureau, the Bureau of Legal Affairs, but I think this will be helpful to this will contribute in our efforts to help our MSMEs. Thank you.
Thank you very much, Nat. And I just got informed by the colleagues that Atty Divina is back. So I may then pass the floor back to her, maybe for one more questions.
Yeah, I think Nora, there are two really interesting questions on the chat box.
Yeah, go ahead, EJ.
Okay, so the question is IPO registration versus license. First to use, first to register. License should be the real actual owner. What stops somebody illegally going behind the back of the licensee and registering with the IPO? in a license agreement, the presumption there is what you are licensing has been registered, because it doesn't really make sense for you to execute a license agreement with an IP that's not protected, an IP that's not registered. So if it's a trademark, then you will only license a trademark, let's say in a franchise agreement, if the trademark is registered. So that if once your trademark is registered, then no one can go behind your back, so to speak, and register it with the IPO, because based on the IPO's database, you're already recognized as the owner of the mark. So again, before you think about licensing, always register your IP first. Now, as I said in my talk, there are certain IP that's not registrable, like know-how. So then that means that you really have to have a license agreement that's airtight with respect to penalties, with respect to any violations, because again, if that person, for example, discloses a trade secret or uses your trade secret, then that will really undermine your position as a company. So better make sure that you have enough penal clauses in your license agreement to punish any unauthorized use of your IP beyond what is stated in the license agreement. The next question is, when the holding company of the licensee has registrations with WIPO in many other countries already. Yes, we do have the Madrid registration here. The Philippines is a signatory to that. So from a local perspective, it does make it tougher for you to register your marks here, because it's possible, because by opening up our registration to people around the world, then they could easily beat you to filing a registration for the mark that you're using. So it's essential that before you consider your creating your brand, make sure that you check the WIPO database, the IPO database, because it will show what marks are already registered, and it will also prevent you from later on dealing with disputes later on. It's always better to have a unique mark that's really distinctive, that is not similar to anything that's out there. Okay, that's it.
Okay, thank you very much, EJ, for asking the questions and answering them too. Thank you very much. I'm really sorry for my momentary absence, but time flies when you're having fun. We have a lot more questions, but we will just probably forward, if the speakers will be okay with that. We'll just forward the questions to them and probably reach out to the people who asked their questions. Yes, Attorney Nat.
Short
Anything to
answer
add?
lang.
Yes po.
There was an outstanding issue in the chat box, which I said that I will answer live. So it pertains to preparation, IPOPHL plan on supporting RCEP once ratified. No? So based on the keynote speech of DG, I would say that we are ready to implement the RCEP. No? Of course, subject to the passage of the law amendment of the IP Code with respect to sound marks or traditional marks. And with the permission of the DG Rowel, I could summarize these efforts through his 6-point bright agenda. So it's in the IPOPHL website. If you want to know what the DG's bright agenda, you can visit our website. So thank you. That's all.
Thank you, Director Nat. Okay, so probably I can just ask for last parting words from our esteemed speakers. The Philippines is really an innovation achiever, and we can see from the efforts of the IPO and the partnerships that they've concluded with a lot of third parties. So perhaps we'll ask for some inspiring messages from our speakers. First, let's start with Attorney EJ.
Thank you, Vina. I just want to reiterate my message that in a digital economy, the stage is now global. So in an MSME or SME, you may feel that you're a small company, but the potential to really grow big is there, because everything is digital now. I mean, we've seen this, small startups that started really, that started as a small company, but they're now huge and big, because again, the digital economy facilitates the exchange of products and services worldwide. quite easily. So keep on creating and keep on protecting your IP.
Thank you, EJ. Attorney Nat, any parting words?
Okay. On the context of RCEP, no, our signing the RCEP is a signal that Philippines is ready to join other countries, on discussions about IP. Of course, there are defensive interests that we might be well aware of, and we should ready to defend. But nevertheless, FTAs, IP chapters and FTAs are meant, designed to modernize and prevent trade barriers caused by the infringement. So, and IP chapters and FTAs will improve not only those partners in FTAs, but also our own IP office, our own IP system. So thank you.
Thank you, Director Nat. We remain hopeful on the effectiveness and the impact and benefits of the IP chapters of the RCEPs. And last but not the least, Honorable Rowel S. Barba, our Director General.
Well, thank you very much, everyone, for listening and watching this afternoon. I hope you got some important information on the updates on what IPOPHL has been doing. Rest assured that we will continue to improve our services. Just give us your feedbacks, comments, and we will consider them. We are open to feedbacks, to your comments, as long as we will improve our services. And rest and wait for some improvements in our website soon. Thank you.
We will look forward to that, DG. Thank you very much for the very inspiring words, DG, Attorney EJ, and Director Nat. So that's it for this afternoon's webinar on behalf of the ECCP and the IPSME Southeast Asia Help Desk. We'd like to thank everyone for participating actively in this webinar. Good afternoon.
Thank you. Bye.
Thank
Thank
you.
you. Goodbye.
Thank you. Thank you.
DJ,
Thank you.
Ternavina,
Bye, DG Barba. Bye,
Bye,
Director Nat.
everyone.
Director Nat.
Kevin Nat.
Thank you.
Thank you.